Gene Trowbridge. Welcome to our YouTube channel, the YouTube channel for Trowbridge Law Group. We're syndication lawyers. We write the documents that you use if you want to raise money from multiple people to to do some investment, whether it's real estate or anything else. And today I'm going to talk to you about 4 questions you should ask the lender about the loan for your offering early. Let's get these questions out of the way while you're negotiating for the loan so you don't have any surprises that come up later, which seems to be happening now in this crazy world of financing and obtaining financing for your offerings. 4 questions. Here we go. The questions all relate to investment LLC. Investment LLC in this picture is the borrower. It owns the property. The lender is going to make a loan to investment LLC. The manager is going to also be qualified for the loan, and we'll have to deal with these questions as they're negotiating and moving toward loan closing. First question, is there a limit to how much any investor other than the manager can invest? Most lenders state a minimum of either 15 or 20% that any investor can invest in the offering. This is so the lender manages their risk. They don't want someone to have a big ownership in the LLC and maybe take over. They underwrote the members of the manager. They're happy with the members of the manager running the property, and they don't want someone that they don't know coming in. If, in fact, you take an investor more than their suggested limit, the 15 or 20%, they are going to require that they, meaning the lender, are going to require that investor gets underwritten, and many times will have to sign the loan documents. Now, not too many investors want to do that. So typically, we find out what that answer is at the beginning of the loan negotiation, and we write in our document that there is a maximum that any investor can invest in this deal, and we lay that out right up front so everyone knows what's going on. 20% is an important number for another reason. Any investor who invests more than 20% must complete the bad actor questionnaire. You, as the syndicator and the sponsor, are completing the bad actor questionnaire because the SEC wants to know that people who are raising money and managing money from other people aren't bad actors, in that in their past they've done something fraudulent toward money raising of other people. Well, there are 2 requirements from the SEC. If you're the manager of the fund, you're going to raise money in the fund, or number 2, if you're someone who's going to invest more than 20%, you are a person that has to fill out that questionnaire, send it to the attorney who's drafting the documents, who will make the decision on whether that person can invest or not. So almost in all cases, we're going to keep the percentage of any one investor to be less than 20%. Now, that doesn't include the syndicator, because the syndicator is already going to be underwritten and is going to sign on the loan. So the lender already knows that. But we need to deal with the lender's responsibility and their requirement of 20% and the SEC's. The second question is, do the loan documents prohibit crowdfunding? And what is the lender's definition of crowdfunding? We just saw recently a lender put a clause in the loan document, and we saw this 3 days before the closing. And the clause said that the borrower testifies that they never used any social media, general solicitation, or advertising in trying to attract investors, and they didn't crowdfund. Well, I don't know what the definition of crowdfund is, but it's the lender's definition of crowdfund. And in this case, no advertising, no general solicitation. And it even went so far as this would include not doing an offering under Regulation D, Rule 506C, where the SEC says you can advertise. as long as you only take investors who are accredited. This lender wasn't going to allow that. So that wasn't a problem for us because our client was doing a 506B where there's no advertising. All the investors were known to the client ahead of time, and he had a substantive relationship with them. So that wasn't a problem. But wouldn't that have been something 3 days before the closing if you found that you could not have used crowdfunding? Now, if you're going to go to any platforms where they take your offerings and expose it to accredited investors, Crowdfund, Real Crowd, CrowdStreet, any of those, you're going to have to know ahead of time what the lender says about that. Now, I think you can get that clause struck if you negotiate with the lender and tell them what you're doing. But right up front, they want to protect themselves. So you need to know that before you go forward to find your investors. Question number 3. Does the loan document require a springing member? Well, this can be a real surprise to someone who's done a number of syndications, and now they're up, and this time they're going to raise $20 million. So they've grown into a different type of loan. The lender has different requirements, different loan documents. And what the lender's concerned about is the members of the manager, typically it's 2 people, something happens to them and they can't carry on. So what's going to happen? Well, the lender requires the name of and the nomination of a springing member. And what a springing member does is they step in when the last member of the manager entity is unable to continue. And it's not just death. It could be bankruptcy, divorce, lawsuits, illness. There are a number of ways that you can be in trouble running your entity while you're still alive. And of course, there is death, and the lender wants to protect themselves. So here comes the clause that says you're going to have a springing member. Well, this isn't Uncle Bob, Aunt Mary. This is someone that the lender will approve of. So what the lender does is they say, go to a certain list of corporations we're going to give you. They are corporations. They last forever. They are in the business of providing staff to play the role of springing members. So you'll go to the corporation. We do all that for you. The corporation will give us documents and will give us the name of today's springing member, and who's an officer of the corporation. And the springing member documents say that if that officer moves on or is unable to do it, the corporation has the responsibility of filling that place. So there'll always be the springing member. So that's something to ask about early on. It only happens in large loans with certain lenders, but I think you should ask that. And 4th question, the last one for this session, is, does the lender require that the borrowing entity be formed in a specific state? Well, on many loans, especially the larger loans, the lender will require the entity to be formed in Delaware. I know people like Wyoming, I know people like Nevada, and a lot of my clients just simply form the LLC in the state where the property is located, which makes some sense. But you should ask the lender what their requirement is before you go out and form your entity. And that's one of the very first things that my clients want to do. They want to form their entity and they want to open their bank account. Well, that can be a challenge. So figure out where the lender wants you to form the entity for the borrower. And then know that if it's in Delaware, or you decide that you're not going to do it in Delaware, you're going to do it in somewhere else, but not the state where the property is. When you go to the state where the property is to open your bank account, the bank's going to say, well, you need to bring that entity into the state and file it as a foreign entity. So now you're going to have entities in 2 different states. You're going to have 2 annual statements to fill out, and that's just the way it is. But sometimes you can get over that if you just file in the state where the property is. You've got it filed, you open your bank account, you only have one LLC to take care of. So those are the 4 questions. We're talking about how much money can any one investor invest. We're talking about does the lender put a limit on how you find your investors through advertising? Does the lender require a springing member on those larger loans? Or does the lender require that the borrowing entity be formed in a specific state? Now, I've written a book on syndication. Actually, this is the 4th edition that's newly printed, newly published, and I want you all to have a free PDF copy of my book. So if you scan the QR code, a grid will pop up, put in your email address, and we will send you a copy of the PDF file right away. I also want to tell you that the hard copy book is available on Amazon, and there's an Audible version of the book on Amazon. So you can just search my name, Gene Trowbridge, or search the title of the book. It's a Whole New Business, and find it some other way, but we will send you a free PDF of the book immediately. So this is, once again, is Gene Trowbridge at our YouTube channel, Trowbridge Law. Be sure to subscribe before you leave and look through our YouTube channel. We have great interviews with syndicators. We have great educational YouTubes just like this one. And I'll see you the next time.